Well, hello, everybody. Just so you know, I do have everybody else muted so that whatever's happening in the background of your life will not get transmitted and broadcast out to all of the people who are attending. We're really excited for this. This is something that we do every couple of years. We try to help really educate your trustees and you and your clients. So if you are someone's trustee or future trustee, welcome. I hope I don't blow you away or scare you away from the job. You've been picked because you've been trusted. So I look forward to, hopefully what you can learn today. This terrific trustee, how to not make a mistake, it's really born from the mistakes that we've seen people make over and over and over again. There are lots of other ways you can make mistakes, but I'm going to hit on the biggest and most common ones. So this isn't everything, but I will definitely try to hit the worst ones so that you can avoid the most common ones. And we're going to be here for, I've planned for this to be about 90 minutes long. So grab your bowl of popcorn, grab your dinner, broadcast this up on the TV, and get back and get comfortable. If we haven't met yet, welcome. I'm very glad you're here. I think you will get something out of this. This is who I am. I always try to give a little intro to who I am just in case we haven't met yet. My name is Francisco Servent. I am the founder of Keystone Law Firm, and I am our senior attorney. I'm also the last person who I ever thought would be protecting nearly $1 billion from probate, but our clients are, they're relying on the systems and the techniques and the tools that we give our clients to use to protect your families, and that's the total sum. And it's awesome because, we don't work for, families who have $100 million plus. We work for folks who just worked hard, they've lived frugal, and they just end up saving some money, and it's their nest egg, and it has to take care of them. But this is just lots of clients, so that's what's exciting about this for me. This is my wife and my 4 kids. Any chance I can, I will brag about them, and so you have to bear with me while I do that. My wife, Nicole. On the outside is my 2 twins, Gabriel and Isabella, and in the middle is Sophia and Zachary, and that absolutely is one of my favorite pictures of our family. Just tons of fun. I love doing what I do, and they really motivate a lot of what I do here as part of my job at Keystone. For those of you who've been around Keystone or me for a while, you've seen my 2 books, I think. My Pack Your Parachute book, which is all about estate planning. My guidebook for probate, that's for people who are stuck in probate. And yeah, there's a blank spot there for book number 3. What's going to go there? Let's find out. I am all about creating a new legacy. I just don't know how to explain how much I believe families can change the trajectory of your loved ones by what you do and every single day of your life. And I truly believe with all my heart that your estate plan is probably, and realistically, it's our last chance to make a difference. It's our last chance to make that change, right? To set them onto a new course in life, and that's what we do. That's why it's exciting, and I love what we do. We help families create a new legacy. What is that? Why? My dad. I mean, I look at my dad. He immigrated from Mexico when he was 26, and just had to hustle, and just retired a couple years ago. Had an amazing career. Raised me and my sisters. Just totally changed the trajectory of, his descendants, essentially, with that big change of moving to a scary new country and establishing a whole new language and everything. My dad did that. I look at my mom. You know, she grew up she was born in California, but grew up in Kansas. And talk about growing up under a very unique family structure with a lot of challenges that could have gone in a very different path. But she decided to raise her family a certain way with values and, you know, with the commitment to doing what's right for other people. And, you know, I look at me and my three sisters and our kids and our spouses, and I think, you know, those values were instilled by my mom and my dad, obviously, but have set us on a path of doing completely different things. And I just look at just my own little family, my mom, my dad, the legacy that that maybe was another option, but they picked what they did, and it is setting their descendants, you know, us, onto a completely different trajectory. And that's exciting. The fact that I get to help and be a part of what you do to set your loved ones off onto a totally new path. And that's what we're going to talk about today. That's how this makes a difference. So here's what we're going to cover, okay? Trusts and estates, it's kind of nitty-gritty. It's in the weeds. It's legalese. I'm going to take it out of that, and it's not going to be that. We're going to talk about what is trust administration, high-level overview. I'm going to give you the 9 steps of trust administration. I'm really excited to announce, you guys will be the first ones to get the benefit of this announcement, my new book, my 3rd book, and I'm going to give you some info about that. It's really cool. And then we'll have I hope we have some time at the end for Q&A. If I can get through, I try to pack in as much as I could, like I always do. I won't get through everything, but I'm going to try to save some time at the end for Q&A. And the system that you guys are logged into right now, it has the ability to do Q&A, so I'll tell you how that works later. So take notes, write down your questions. I'm going to try to save a spot at the end to do that, some time at the end to do that, okay? Okay, what is trust administration? Big picture, trust administration is just the process of collecting, managing, and distributing the assets of the trust. Okay, whatever the trust controls. It might be bank accounts, investments, property, personal belongings, vehicles. It's whatever's titled in the trust name. That is the administration of the trust. Okay, what else is it? This is the process of unwrapping that new legacy. This is really it. This is the last chance that whoever created this trust, this is their last word. And so if you're the trustee, you've got a big job to do to pass that legacy on. And so this is the start of that. That's what trust administration is. It's that last chance for us to make that difference. So real quick, I want you to take a lot of notes here. You're going to take a bunch. You might get enough out of this that you think, all right, I'm good, I'm armed, I can do this, or I can tell my trustee how to do this. If you don't get enough, or you feel like, oh my gosh, there's still so much more, that's what the book is for, okay? The new book, here it is, bum, ba, da, bum. It's not exciting at all. It's called My Trustee Manual. It's for you to give to your trustee. That's all it is. I finally just said, you know what, we need this tool because there's so many questions along the way about so many different things, and it's always the same questions. Not always the exact same, but it's some variation in one form or another. So bam, put it together in a book. Here it is. And that's what I'm going to tell you guys about at the end, about how you can get a copy of it, because I want this thing to get out there. I want this information to get out there. What to expect when someone dies. Okay, this is when the typical job of a trustee springs into life. Losing a loved one, it's never easy. There's always tough things that happen. I mean, it could have been a long, drawn-out illness. Could have been, somebody died suddenly or unexpectedly, and at that moment, everything changes. Everything does change. I know that not everybody has been in a business or has served hundreds and hundreds of families who've gone through that transition, who were here and then we're gone, and what happens afterwards. I've just seen that happen hundreds of times, and it is a lot of times like that person was just the glue that held the dynamics together. And a lot of times that legacy it really brings people together even when they're gone. But family members, at some point, they turn and they start saying, when am I going to get my share? When is the process going to start happen? I'm sure Aunt Ethel wanted me to have her wedding ring. She said I was her favorite. From the legal perspective, okay, a trustee, the distributions have to be made according to the terms of the trust, period. There's nothing outside of that. So trustee, you can't have people rushing into the house and clearing things out, even if they're entitled to something. There has to be a process to confirm what it is and go through the whole thing. That's what we're going to cover, okay? There's expenses, there's taxes, there's creditors. All this stuff has to happen before the beneficiaries just spring in and get to sweep and raid the house. Okay. One of the things that has to happen is notice, and this is why you can't just, there can't just be a free-for-all. Look, the family is going to be aware that the family member has died, but the rest of the world might not be. And that's why the legal process has to be followed. And as the representative of this deceased person, it is your job to make sure all those outside entities, you know, individuals, creditors, government agencies, all have notice. Social Security, Medicare, IRS, Secretary of State, credit reporting bureaus, all of these things. So there are steps you have to take to protect the estate, to protect the trust. It's a lot to handle. That's why you're here. Let's get you some more info. It does trigger when somebody passes away, but a lot of times it'll trigger first when somebody becomes incapacitated. Okay, this is critical. You've got to be prepared. You've got to be careful about this. You can't ignore this. So in the timeline where you're alive and well, right, in that phase of life, you do whatever you want with your trust. It's your trust. There's no problem. You literally do whatever you want. It's your own money. Incapacity, I wish it were always a black and white, immediate, we know what happens there, because that is the exact triggering moment when the trustee's job kicks in. But sometimes it's not clear. When does that happen? So you just need to know, incapacity is a sliding scale, may not be a definitive moment, and so there's some judgment that comes into deciding when that's going to be triggered. It's okay. We know that may not be a very clear answer, and I'm okay with that. If you have questions about when that triggers for you in your specific situation, at the time, that's what professionals are for, okay? We'll help you analyze that. Your doctor will help you analyze that. And with the two of those things, you can make that decision of, okay, we're not there yet, or yes, we're there. And it is a spectrum, it's a sliding scale, but at the moment, whenever that moment comes, that's when the trustee's job kicks in. That's when the trustee starts to have responsibilities. There's a lot of them. Let me give you the first few in just a highlight. Okay, number one, to secure and safeguard the assets. Number one is absolutely secure and safeguard the assets. Number two is to communicate. Your job is to communicate about the trust and the administration of the trust with the beneficiaries. There's some information you have to provide to them. The two things is accountability and transparency. You have to be that with the trust, with the beneficiaries. You have to make sure that all outstanding financial and legal obligations are resolved. Okay, whether you're picking up at incapacity or at death, you're not taking on the liabilities yourself, but you're taking on the liability of making sure they are satisfied. And then finally, to distribute the decedent's possessions according to the trust. Hold on, I got to say one thing. Happy birthday, Michelle.
Thank you.
To distribute the decedent's possessions according to the trust. Period. You don't get to deviate from that. It's according to the instructions. That's why it's done in a legal document. Okay? Those are the 4 big responsibilities that we're going to break down in a minute. What if the trustee makes a mistake? Let me just cover this before I go into the 9 steps of administration. What happens if you make a mistake as trustee? It can happen, okay? And it can happen either intentionally, which isn't a mistake really, but, right, it can be on purpose, you're just doing something wrong, or it can be completely unintentional. The result is that the trustee is personally liable for the mistakes, okay? Doesn't happen, it doesn't matter whether it's intentionally or not. It just doesn't matter whatsoever. As trustee, you are stepping in and you're saying, I will do the job appropriately. And that means you are signing on saying, I'm going to do it according to the law, according to the trust, according to the tax code, according to everything that's legal. And if you make a mistake, whether it's an honest mistake or not, you, the trustee, you do take personal liability for that. And I mean personal. So, you know, the hard ones are if you file the taxes wrong and a year later they come back and you've distributed all the money, the IRS comes back and says, oh, it's wrong. No, the trust actually owes another $10,000 in taxes. If the money's all gone, guess who they're coming after? They're coming after you, the trustee. If, you know, we've seen some cases where you needed to sell some real estate and it wasn't maintained very well, you know, just like landscaping, things started to go bad, and then it took a lot of money to get it back up to par. That could be the trustee's problem. If you weren't watching the investments in the stock market closely, and all of a sudden there was a big giant dip in the market, well, we just saw that happen, right? That can be held against the trustee. So there's a lot of things that the trustee takes personal liability for when they take on the job as trustee. So we see some trustees, you might hear the word bond. They want to get a bond just in case they make a mistake. That's the insurance company who will make it right for the beneficiaries. Lots of things. Don't make mistakes. That's what you're here to learn about. 9 steps of trust administration. Okay, ready? Number one is to locate the estate planning documents. Okay, this is one of the biggest and most important first steps. You've got to find this stuff. We get called in a lot. So if you don't know, we help people draft and create these trusts. We help them execute and carry these out when needed. We help do that whether they were our clients or not. They don't have to be our clients. And so that means sometimes we get called by families who didn't do their estate plan with us. And when that happens, sometimes we run into some very interesting stories. Well, we just literally finished dealing with one case where they knew there was a trust and a will. They couldn't find it anywhere. And this is the family, and they, digging through records, digging through the house, digging through everything. They finally find something that says they have a safe deposit box at the bank. Well, great, go to the bank and open it. Well, the bank won't let you open it because it's not your safe deposit box. And so what has to happen? We have to literally go to court to get a court order to open the bank safe deposit box. Right? Whole bunch of costs, whole bunch of fees, whole bunch of time delay that can't be recouped. Right? They put it in there. Somebody told them it was a good idea. They thought it was a good idea. It was a bad idea. Our recommendation is to never do that. Don't put them in a safe deposit box. It's part of the reason why we make them so big and giant binders. You can't fit that in a safe deposit box. Put them somewhere it's easy for your family to get. And so locate those documents as a trustee. That's your first job. Go find them, get them in your possession, and don't let anybody take them until you talk to an attorney, period. Don't let anybody take them. That's just always the first step. Second step, you're going to start to look for other things. Okay, other things. You might find in those first documents, the will or the trust, some initial steps that you can take. You might see some things in there that say, go ahead and distribute, my clothes to charity. Go ahead and whatever, fill in the blank. And if it is simple things that won't affect the overall administration of the trust, then you can do it. You do take the responsibility, the liability of it coming back to bite you later, but you can. You can do that up front. Second is really you got to gather that important information. And this is all of the important asset information, okay? The insurance, the real estate, the bank, the investment, the IRAs, the life insurance, definitely the last tax return. Anything that might have to do with an asset or piece of property, maybe you just find the property tax statements. That's perfectly fine. Get all of that stuff, start a little file, and organize it as best as you can, and just start taking inventory of that stuff. If in the house there is some important items, if there are either items that have high dollar value or they have high sentimental value, you need to take control of those. You need to essentially lock those down and make sure they don't start wandering off. Truly, you are liable for that, and make sure you do an inventory. Sometimes in the house, it's just a good idea to just go through and take pictures. We all have a camera on our phone now. Just take pictures of everything in the house that you can think of, not every single drawer or cabinet, but where things are that are important, take pictures of those rooms. That's your second job. And then start to inventory that stuff. What I recommend is even make another list of it, right? Make a summary list that shows everything that you have on that one sheet of paper. Third step is to meet with the estate planning attorney. I always recommend that if you can speak with the estate planning attorney before you speak with any bank or investment or notify the creditors or anybody. It's a great idea, because with all of that information in hand, you can sit down and then map out what the steps are to administer the trust, and you won't be jumping the gun. Depending on the amount or the type of the accounts, there's going to be lots of things to consider. You might need to go this direction or that direction, and you don't want to jump the gun. You don't want to start promising things or telling people things before you can see what that process is going to look like. And that's going to help too, because once we've reviewed the legal documents and what you gathered in step 2, all that important information about the financial assets and the property, then that will let us draft the first set of documents that you are going to need as trustee. You usually can't just take that trust or the will and walk into the bank and say, I'm the trustee, let me have it. You can't just go sell the property. You can't just go cash things in. There's legal documents that you do have to have created at that point to give you authority as the trustee. That essentially is the proof that you are who you say you are. And that's what the estate planning attorney is going to do, is help you craft those documents. Okay? Number 4. Make a list of debts and creditors. This is where you're then going to start to see what the scope of the liabilities are. There's going to be all the ones you know about, and then you're going to start to learn about ones you didn't know about potentially. Because, I mean, even in death, right? I think they say death and taxes are certain, but I think death and creditors and taxes are certain. You don't avoid your creditors just when you die. So before any distributions are made to the beneficiaries, all of the creditors, all of the debts have to be satisfied. If there are funds left over, that's what gets distributed to the beneficiaries. So now, with the debts and the creditors, from the moment of the trustee's first authority, that the trustee has that proof from the attorney that says, I'm the trustee, I can do this job, I'm in charge. From that moment, there's generally speaking, there's a 4-month window before you really have to make any payments to any creditors or any beneficiaries. You're not going to make distributions to anybody if you don't have to. You might need to pay utilities on the house. You might need to pay the mortgage on the house. You might need to pay some costs and expenses of administration, but paying off the credit cards, paying off the medical bills, those things do not have to be done during that 4-month time period. They all know they have to wait during that time period, which is good because you can accumulate and figure out what those are. By the end of that 4 months, you should know what all of them are, and then you know what that creditor liability is. You don't have to wonder and do it piecemeal. You get to do it all at once at the end of the 4 months and then do it all together, okay? In rare cases, it's not common, it's pretty rare, the debts will actually exceed the assets, the total assets. And that's what we call a insolvent estate. It's unfortunate. It's only, it's pretty rare. But when that happens, it requires a very complicated analysis of how the debts are going to be paid. Because in that circumstance, we're sort of doing a bankruptcy through the administration process. Though we don't have to go through bankruptcy court, it's sort of a bankruptcy. So just be aware of that. That's why you don't want to start making distributions or paying off creditors during this time period, because if by some weird stretch of the imagination we get to the end of that 4 months and we add up all the creditors and it happens to be as much as the assets, we've made ourselves a big problem. So wait that 4 months, accumulate all of those. Make yourself a list. Okay, we've got this credit card and that one and this one, and we've got the mortgage, we've got maybe a car loan or whatever. You're going to accumulate all of those, make an inventory of your debts and your creditors. During the 4 months, though, you are allowed and you should be paying things that are required to be paid to maintain the value of the trust, to maintain the trust assets. So you need to pay utilities on the house. You need to maintain the house. You need to pay, you're going to have to pay some maybe tax bills. You maybe have to pay some expenses to meet with the attorney. You may have to pay some to meet with the CPA, to whatever. Those are all expenses that if you have to pay those, you have to pay those. And that's fine, that's expected. But all the expenses, all the debts and creditors can wait until that 4-month window, okay? Okay, number 5. You're going to want to make a list of the beneficiaries who are named in the trust to receive something, and anybody who would be considered an heir-at-law. And that is definitely something you're going to want to get some legal advice on. Who is an heir-at-law? That's going to vary somewhat by family. It's dependent on if you have kids and grandkids, or if you don't, or if you have some kids who maybe have passed away before you, or if you have estranged or disinherited kids, or you have kids who you adopted, or you have stepkids, or there's just so many variations to that it's kind of a little bit of an analysis, and that's where real legal advice you're going to need to know. So beneficiaries are those who are named specifically in the trust to get something. Heirs-at-law don't have to be named at all. You could even disinherit them entirely. You as trustee need to make a list of who they are at this time. It's part of your job. And you're going to have to determine, sometimes we do disinherit some actual heirs-at-law, and I know it's not something people talk about politely in public. Certainly I want everybody here to know it happens more often than you might think, and if that's you, you're not abnormal. I want you to know it's actually kind of normal. It's probably like 1 in 4 families actually disinherit someone. And so if that's you, if you're a trustee and that's what the plan is to specifically exclude an heir, then you need legal advice to figure out how you're going to address that. Because there are some very strategic things you may want to do, and there's some very specific things you may not want to do at all that could create more problems for you in administering this trust. So, but again, there's going to be some options there and some strategy involved in that discussion. I've seen it go both ways where, we had one where client left their estate to their 4 kids, but they didn't give them equal shares. And whenever that happens, I'm always a little hesitant, just because I've seen it happen enough where somebody who's not getting an equal share, quote unquote, it can hurt their feelings, obviously, and if they didn't know about it. And in this case, they didn't know that that's what the plan was going to be until the trustees showed them the trust. The 4 kids had a great relationship. They were kind of worried, right? I mean, they have to tell their sibling, I'm getting more out of this trust than you are. That's what mom and dad set up. And I always kind of wait with bated breath, especially when it was one of our clients, to see what the reaction is going to be. And in that case, the beneficiary actually went and consulted with an attorney about challenging the trust and trying to contest it. Thankfully, we responded. We sent out the letter, this kind of a standard letter that we send out to those types of initial inquiries. And we say, here's how the trust was written. Here's what it means under this section and that section. Here's how that applies under Arizona law. And if you continue to take steps down this path to contest the trust, that means we will trigger this other clause, which means you get nothing. And so that's our response. And so far, we've had to send about 5 or 6 of those letters on behalf of our clients' estates, and every single one of them have not challenged the trust. And so far, we've had every single one of our trusts honored exactly as it's written, which is just awesome. For you guys, it's awesome for you guys. So in that particular circumstance, the trustee made a very strategic decision about what and how to inform their sibling that they were getting less than the rest of them. And it worked out exactly how the parents intended. And what was even more kind of neat about it was the beneficiary, after they got our response letter, they came back around to the trustees and they said, yeah, I get it. This really was what mom and dad wanted. And I actually understand why they did it. And it from what I hear, it didn't cause any more, rift between their siblings. And that's what I'm glad to hear. That's what it should be doing, right? Your estate plan shouldn't cause more division between your loved ones. It should, if anything, it should bring them closer together. And so I was really excited about that one case for that to unfold like that. But that's why the strategic, advice is really critical in that moment. Before you start talking with beneficiaries or heirs, you want to have that strategy in your toolkit. Number 6, we're going to go to the personal property. You, as a trustee, one of the things that almost always happens when somebody is creating the trust is that they say in part of their legal documents that all of their personal property and jewelry and valuables and vehicles and all that stuff is now part of their trust. Even though, your favorite mug that says Keystone on it, if you guys can see the video, haha, even though it doesn't have a title that you would re-register it into the trust name, there's a document created that says, I hereby transfer all that stuff to my trust. So you as the trustee, if that is part of those documents, it is for our clients, then you should make an inventory of those pieces of the trust. Those are trust assets, and you don't want to ignore that. The worst thing that happens is when someone dies, there's this mad dash into the house to just clear it out and pick through everything, and it's a free-for-all, and it's just like a raid. People have this, I just have seen it, not so much with our clients, a little bit, a couple times, but people sort of see, I'm not getting my fair share, and so they rush into the house, and we've seen trustees who don't stand up and assert their authority to say, no, I'm sorry, that is not allowed. You can't do that. I'm sorry, guys. This is not the way this is going to happen. The trustee has to be able to say no. You have to be able to say, guys, not today, not this way. It will be distributed. It will happen, but this is not how we're doing it. It's crucial that you as trustee know what's there and know how to make those distributions. There's been a few cases where we've had to get involved with a family member, a loved one who passed away, and they had their house was a near hoarding situation, and there was just possessions, stacked in boxes in every corner, in every room, 6 feet deep, and it was felt impossible to try to unload that. And I just want you guys to know, I don't go into those homes, and I don't do that, but we actually have somebody who does, and they help organize those. They help sift through that to find those jewels in the rough, because sometimes there is that thing in there that's valuable, and they can help inventory that. You don't have to be the one as the trustee to go through and do it. You can have somebody do that for you. And I know it's an expense out of the estate. It is, I get it. But it's also a way to save your sanity and potentially to help you not be the one accused of as being the bad guy who didn't do it appropriately. If you get a professional in there, they do it. They're super objective, independent, neutral. They don't care what anybody says. They just want to do a good job. So just be careful about that. If there is a concern about getting that done right, make sure that you're welcome to ask me. We'll refer you to them, and they'll help you figure out what that would look like. Just don't start unloading and giving away personal items too soon. It's impossible to undo that. So just up front, tell everybody. You can just blame the lawyer, and you can say, I've got to do an inventory. You can blame it on trust law, on probate law, and you can say, as soon as we get to the right place, I will make sure to do to give you guys the free-for-all time to do it, but it's not yet. And just keep a pause on that until you can. Job number 7. File income and estate tax returns and pay any taxes due. Woohoo! Taxes, fun, yay. There are, as a trustee, you need to know about the 3 different kinds of tax returns you may have to deal with. And yeah, I said 3. There are 3 different kinds of tax returns you have to be aware of. When a person dies, they still have to file an income tax return, that's the 1040, for the year that they were alive, the year that they died. Because they're no longer alive, it's now, guess whose responsibility? It's now your responsibility to make sure that that final 1040 is filed when it is due. Okay, that's the first tax return. And you're going to kind of go through the same process they would have gone through. Collect it all at the end of the year, go to the tax person, look at whatever deductions they could take, and file the tax return. I mean, it's not any more complicated. It's not any more simple than that. It might be a real pain in the butt. Generally speaking, I recommend you use the same tax preparer that they used before. If they didn't use one, they did their own taxes, then maybe you use your tax preparer. There's one here at Keystone Wealth Partners. They don't always open their tax services to just anybody, but it's worth asking. But that final tax return, it's got to be filed. That's the first tax return. The second tax return, when a person dies, the trust now is its own entity. Okay, from the date of death until it's closed, it is its own tax entity, and it will have its own tax ID number. So that's going to be another tax return you got to be aware of. And guess whose responsibility it is? Yep, it's your responsibility to make sure that tax return gets filed on its own timeline. It'll be different than the 1040 for the individual who died. It'll be filed at a different date, different due date. It's called a 1041. So it's not, and you need to be aware of this. This is a key distinction here. Most people who do taxes every year, income tax returns for people, they've either never done a 1041 or they've only done a couple. They're very different. Don't assume they're comfortable or happy to do one just because they did the 1040. You may need to go to somebody who does a lot of 1041s, okay? They call those, if you want the industry jargon, they call those a fiduciary tax return. Just so you know, that's the 1041. And it's done on a fiscal year basis, so from the date of death till 1 year later, and then it's generally due, 4 months or 3.5 months after that year. So that's the typical fiscal year for a 1041. Okay, the third tax return you need to know about as a trustee is the estate tax return. And that is going to be relevant for anybody who, if you die this year, which I hope, God forbid, okay, that nobody has to deal with that. But just so you know, 2020, the estate tax exemption or the coupon, the free amount, is $11.58 million. So you as the trustee, if you're dealing with a trust that the person died this year and their total estate is under that amount, $11.58 million, then you do not have to file the estate tax return, okay? It means you do not have to file it. If it was a married person, okay, if their surviving spouse, if you have a spouse and there was a death in 2020 and it's under 11.58 million, you may want to file an estate tax return for strategic reasons. There are some very good strategic reasons to file one. You can get some huge tax savings for the surviving spouse. Lots to talk about in there, okay? But that's something to know about. If it's under 11.58, you don't have to file one. But if it was a married couple, there may be some good tax strategy there. You may want to file one anyway. If you're the trustee and it's over that, you're going to have to file one. And any dollar amount over that, if you have 11.58 and you've got another $1 million, that $1 million is going to pay 45% in taxes to the federal government. State of Arizona doesn't have any estate tax, so there's no additional estate tax that's going to be owed to the state of Arizona. That is just a federal tax, okay, right now. As just a quick aside, since we're right here in the middle of election season, there are a couple big proposed changes. I guess there's two proposals. There's two tax strategies that each candidate is proposing. President Trump is proposing that we continue with the current estate tax coupon, that 11.58. It's got that 0.58 because it's indexed for inflation every year. So he's proposing that we just make that permanent and that continue. Former Vice President Biden is proposing that we roll that exemption amount back to what it was in 2009. It was 3.5 million. So if he gets elected and that gets passed, we're going to see a shift in that. Nobody knows if that would be in effect at any time, but if it did go into effect, instead of 11.58 million, it'd be 3.5 million. Anybody over that would require the filing of this estate tax return, okay? So since we're in election season, I just figured I'd mention that, because if it changes, then for those who are watching this after the fact, will know how that issue would affect your job as trustee. Okay, that's job number 7, is filing the income taxes. Job number 8 is one of the ugliest and honestly, it's one of the least Fun. Ugh. There's no part of being a trustee that's fun. Every part of being a trustee, I think, is it's atrocious. It's just a horrible job. It's a thankless job. If you've ever done it, send me an email about what you thought the job was going to be, and send me an email, and then in the email tell me what the job actually was like. And I want to use that as a testimonial for people who are saying, I'm going to bestow this honor on my eldest child to be my trustee. It is just not an honor. I mean, I guess it is. Maybe it is. I don't know. Anyway, somebody put in the comments there, accounting is a blast. Okay, you're an accountant, I bet. I love spreadsheets, but man, it's just a tough job. And the type of accounting that you have to do as a trustee is different than any accounting that is taught anywhere else. It's not like, reconciling your checkbook. It's just not like it at all. Number one rule, you as a trustee, you only are allowed, I'm telling you, to pay expenses on a card or with a paper check, right? A card or check, or electronically, right? If you want to fill out the check electronically, fine, I don't care. Card or check. You don't get to pay things in cash. You don't get to just nilly-willy start moving things around. A card or check. You want a paper trail for everything you do, period. I don't care. I just don't care. Make a paper trail of everything you do. Because even if your family gets along great, it's all hunky-dory, and everybody loves each other, somebody might crawl out of the woodwork and launch some attack at you, and oh my gosh, now you have to account for everything. You just don't. I just had a consultation with somebody who literally was asking if they could challenge the administration of a trust that was completed 23 years ago. And you know what the true answer was that I had to give her? It was, well, it depends. You actually might have some rights to challenge this. Now, I'm just thanking my lucky stars that I wasn't even practicing 23 years ago. This wasn't anything I was involved with. But the true legal advice was, there might be some opportunity to challenge this. And if you were the trustee on that 23 years ago, you don't want to be called back into court unless you had done things the right way. The reason there was some opportunity is I could see just off the top that things weren't done right. So maintain your trust accounting, do things the right way so that 20 years down the road, you don't have to worry about it. Here is how you do it. Number one, you keep a paper trail of everything. Everything. I mean, do not keep that paper trail of everything. You need to have a beginning balance. Okay? That's why you've got all those records. A beginning balance, and that is the date of death, at least. If you started the job while they were incapacitated, you need to have a beginning balance on the date you stepped in of their incapacity, the date you took over. That's your beginning balance, okay? That date. But whatever the date your beginning balance is, here was the balance of the checking account, the savings account, the IRA, here was the value of the house and the balance of the mortgage. Here was the balance of the credit cards. Here was the balance of the stock account, the mutual funds, the CDs, everything. Here's the stuff in the house. We had this car, that car, and an RV. We had a piece of property up in Sholo. We had a piece of property in California. We had a part of Grandpa's mineral interest in North Dakota. Date of death, everything with the value. That's your beginning balance. Then you're going to need to track everything that you pay out, okay? Expenses and for what? All of those payments. You paid a mortgage payment. You paid a utility bill. You paid legal fees. You paid your trustee fees. You paid taxes, whatever. All those expenses is money going out. Then you might have a column that says, hey, we sold the house and now it's cash. So you kind of have some internal conversions of things, right? Or you may have, hey, we value, at the date of death, the stock was valued at $100,000, but now the stock has gone down a little bit. It's $97,000. Okay, you had some adjustments downward. So you have your expenses down, you have your value going down. During the accounting period, you might have received some money, okay? You got a life insurance check. You received some income. Maybe there was a rental property and you got some rental income, whatever, dividends off of a portfolio, whatever, right? You've received some things. Those are the additions. Or maybe you had some stock values go up, right? We valued it at $100,000 on the date of death. Now it's worth $110,000 here later. Great, that's a value up. So you have beginning balance, you have money out and value that's dropped, you have money that's come in and value that's gone up, and then guess what that gives you? It gives you ending balance. Okay, ending balance. And this should be at the end where you're ready to start making checks, right? Cutting checks, right? Or distributing property, whatever you're going to do. Those are the steps of accounting that make sure you don't have to worry about somebody coming back sniffing through all of this, accusing you for doing it wrong. That's really hard to do, honestly. We like I said, we get involved administering estates and trusts, whether they were our clients or not. And a lot of times what we're doing is we're representing a beneficiary who knew that a trustee did things wrong. And I mean, we're seeing trustees who are paying their own bills out of the account, who are distributing money by the tens or hundreds of thousands of dollars completely inappropriately. They're not keeping track of anything, and it's a mess. And or on the flip side, we get called in by a trustee, 6 or 8 or 10 months later. Here's a sad example where we got called in because the trustee had been trying to do the job of winding up the trust. And the family wasn't necessarily like threatening to sue or anything, but they were kind of like, hey, it's been almost a year. Are we gonna start seeing some movement here? So they finally came and said, look, can you just help me get this in order? Yeah. When we got to the point of we got to do this accounting, it was a big project. It was a mess because we had to go through and dig up the records and get all the bank statements, and just helping them clean that up is tough. And it's so much better if it's just kept up to date month after month after month. So do your accounting month by month by month. Don't let it get to the end. We see accountants who haven't been trained in this get it wrong. So just know this is a project, okay? And you want to do it right. This is really where the rubber meets the road, so people can see the transparency that what you've done is right. Let me look at my notes on the accounting. I know it's a lot. The idea here, the concept of this, isn't just to give you extra work as trustee. The legal concept is that there are people that are entitled to this. It is the beneficiary's money, and you're in charge of it. And so the law says you've got to be able to tell them what you did with their money. And that's what the accounting shows. It shows what did you do with our money. And they're entitled to that information, okay? So this makes it so that you can be super transparent and you can say, look, right here, boom, 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 here's what I did. And if you do that month after month after month, it makes it so much easier. All right, final step, the step everybody's waiting for, the step everybody wants to know about. Distributing the property. Hallelujah. Let's, send me my money. Where's the money? Distribute the property, the accounts, the jewelry, the valuables according to the trust. And it might come in the form of writing a check. Here's your money, here's your money, here's your money. It might come in the form of, mom and dad said you get the house, so I'm signing the deed over to you. Or the car, or a specific stock account, right? Excuse me. It can also come in the form of not necessarily here's the money. What a lot of our clients do is they create their estate plan, they create their trust, and they say, hey, I want to give my loved ones their inheritance inside of their own new trust, a protected trust. And so you guys maybe know about that for beneficiaries. And so the trustee might be saying, here you go, I've created or I've implemented your beneficiary protected trust. here's your trust, and they hand that over. And now the beneficiary gets to take over control of that trust and run with it. And they're now trustee of that trust. And that's cool because that gives them lots of asset protection from creditors, from bankruptcy. It stays their separate property if they were to ever get divorced. They have much more, they get to say who it goes to at their death, right? Eventually, when they pass away, it doesn't just automatically go like to their spouse or to their kids. They get to have some say in that if you didn't make specific instructions. But so anyway, it could go in the form of a trust to the beneficiaries. That's number 9. That's the last big step that the trustee has to do. Now, there's some sort of sub-steps under here that the trustee needs to be aware of. First, before you cut these checks, before you distribute property, before you distribute their subtrust, what you're going to do is you have already cleaned up all the debts, all the liabilities, all the creditors. Those have all been satisfied. You're then going to, what we recommend is create a proposal for what you're going to distribute. Just write it down in a proposal, and there's some legalese, boring but important legalese you can add to that. You give to the beneficiaries. You say, hey, here's how I think things are going to shake out. You're going to get this, you're going to get that, you're going to get this. You give that to them, and then you let this certain amount of time go by under the statute, Arizona law, and then after that, that's their opportunity to object. If they never object, you are protected as trustee. It's a great level of protection. Then you cut the check, you distribute the deeds, you distribute their subtrust, and you're good to go. We always recommend you, though, hold back a small little reserve dollar amount. Okay? So I'll give you an example. If you're distributing $1 million to 4 beneficiaries, don't just do, and let's just say it's equal, 250, 250, 250, 250, boom, I'm done, right? As trustee, maybe you've got $0 left in the bank. That does empty the trust out. But what happens if in, a couple months you get a weird bill in the mail, a weird tax notice, a weird thing from the CPA? I don't know. What are you going to do? And if it's legit and you have to pay it, your only option at that point is literally to pull in your own pocket and pay the bill, because you as trustee, you're personally liable. You can try to chase the beneficiaries down. I'll tell you, it's what happens most of the time is that money's gone. It's already spent, right? It's already spent before they even get it. So as soon as they get it, poof, it's gone. New car, they paid off the mortgage, they made some investment that they can't get back. So what we recommend is that you hold back a reserve account. You make 98% of the distribution, that final distribution, or something close to almost all of it. You hold back an amount that's equally dividable by your residuary, your final beneficiary. So if you have 3, you can make it something easily dividable by 3. If it's 2, if it's 5, whatever it is, whoever's that final ultimate equal or percentage split, you make it equally dividable so your math is easy. You just hold it, keep it in the account, and that's going to be, and you're going to tell them, hey guys, I'm holding a little reserve back just in case, and in 6 months or in a year, when I really feel good that there's no other bills, I'll close that account and split it up. And that's all you do. You just wait, right? You just wait 6 months, a year, whatever you feel comfortable with. And then at the end of that time, you write those final checks, you split it up, and that is what completely empties the trust out. There's a little notice you send to all the beneficiaries that say the trust is closed, and you're done. And poof, the trust administration is over. It's totally over. The only thing that might continue is if they got beneficiary protected trusts, those will then continue to be administered by them, by the trustee of the beneficiary trust, for however long that thing goes. And they can go for their lifetime. They can go until they've spent all the money. It just gets administered like that. And that's the whole scope of trust administration. It does take all of those steps to get to this last step of distributions. My recommendation whenever you pick up the job of trustee is you very, very, very quickly give the beneficiaries a copy of the will and the trust. Just get them a copy of it. That is sometimes the most emotional piece is get them a copy as quick as you can. If you need legal advice for some strategy on that, get that quickly, because the sooner you can get that, you buy yourself a little more time. And then at the same time, right away, is tell everybody, I already know, we've already been warned by the estate lawyer that distributions usually don't happen for like 6 or 9 months. And sometimes there's a little bit that happens at, sometimes before that, but the main distributions, they just don't happen for 6 to 9 months. And I don't know why. We're going to figure that out. I'll get you more information, but just plant that seed in their mind. Set their expectation that this is going to be a while, so they don't go out and borrow a bunch of money or do something financially silly that they can't cover for the next year or so. Make sure you set that expectation properly. What I hate to do is to have to undo that expectation. And sometimes it's the first time that they've heard it when we tell them, no, this is like 6, 9, 12 months. And if it's an ugly, messy thing, some of you guys have friends that you've referred to us to administer their family's estates, and it's been messy. And, those are 12, 24, sometimes, 24 months, sometimes 3 years before we're making distributions, because there's just a dispute happening, and distributions are not going to happen until the dispute is resolved. So just be aware, okay? That final step is the big moment of that new legacy happening. This is where it's happening. And while you as trustee are going to give up sort of your control over the trust at that point, I 100% believe with all my heart you have a moral obligation, I absolutely do, to try to instill some financial wisdom into these beneficiaries. You have an obligation. You might be turning over an amount of money that they have never experienced before. It doesn't matter the scale of it. Sometimes we're turning over $1 million. Sometimes we're turning over $100,000. Sometimes we're turning over $10,000. The beneficiary a lot of times has never been trained how to handle a lump sum like that. And I absolutely believe it's your job as trustee to instill some wisdom in them about, here's what this means for you. Here's what this could mean for you. Here's what this could mean for you in a good way. Here's what this could mean for you in a destructive way. And to make an introduction to a good professional to help them get some good financial advice. And I absolutely believe it is your obligation to do that. You can't hold the check back, right? Your job is to make the distribution. But I believe you have that opportunity to instill some important financial wisdom at that time. And so what should you do next? This is where I really am excited, because I want you guys to know about this book that I'm just really proud. This is, if you guys have seen my first 2 books, they were written, I don't have a copy here to show you, do I? To wave around and brag about. I do. So I'll hold up one of them. So this is my first book, Pack Your Parachute. I was in the process of editing and revising this one when it hit me that I needed to do this other one first. So this one's got a second edition that's going to be coming out, and there's going to be some huge revisions to it. I haven't decided. It might actually turn this one into 2, but it got me much more. It got me much more thinking. This one is doing a good enough job right now. I need this one out. So we got this one put together for your trustees, and it is bigger and better than anything I hoped. I'm just so excited about it. It's my trustee manual. So you have one of these books. You know these are short and to the point. I think they're about 50 pages of content. Yeah, they're about 50 pages of content, but it's pretty short pages, okay? These are, it's one of the smaller size books. This book is 24 chapters, and it is 150 pages of, I don't have any of the copy here with me, but full 8.5 by 11, 150 pages. I packed everything in here. This is everything I could think of to help you prepare your trustee. That's what, this is where the legacy, the rubber meets the road. And so everything is in here that I talked about today, but in much more detail, okay? All the do's and don'ts, the checklists that are needed, how to work with the beneficiaries much more specifically, the duties, the powers, the liabilities, the record keeping, like in detail, how to keep the records, how to account, more information about how to make those distributions when they're needed. There's a whole thing in there about how to gather the information you're going to need and organize it so that you can do that as a trustee. I don't know. There's just a ton in there. That's this book. This book is a giant. It's massive, and we are very, very, very proud of it. It's much different than my first two books right now. This is intended to be an operating manual where your trustee can open this and work through it and do the job. Okay, it's 150 pages. This will be a different type of book. It's $199. But it is, I just think it's an awesome tool that we're going to just put on our website when we have the official launch to do that. And we'll just let people grab that thing on our website. I recommend every single one of my clients get this when it's available, because I want you to give this to your trustee and say, hey, I know this is a big job I'm asking of you, but I'm going to help you prepare for this, and here's the manual to do it. So this is what we're announcing. I'm super proud of myself, my team. I'm just happy that we got this ready for you. It's almost ready. The paper version is not quite ready. It's not in print yet, so you have to wait for the print version. I'm sorry. It will be ready soon. My goal is to have the print version by January 1st. But what I do have, which some of you will love, some of you will hate. I know who you are who would hate this, but hey, you're on the computer right now, so you might like it. I do have, not the print version, I do have a digital version ready to go. Just about ready. We're going to launch it on November 1st. And the digital version will be $99. It's going to be all the same thing. It's 24 chapters, 150 plus pages, and I want as many people to get this as possible, delivered straight by email instantly on November 1st. And this is my next attempt at really helping my families, you guys, create that new legacy. I think it starts with those conversations we have with our family. It starts by taking action every day. This has been, for me, this last month, an exercise in doing something totally new in my life, but it's little tiny things that we do every day. Last month has been the best success I've had at journaling every day, just a few minutes. It starts with little decisions like that, just taking action every single day. And so I've got this streak going that I don't want to break, which has been kind of life-changing for me. Small steps, and I can see this new legacy it's helping me create for my kids. So this is one of those things you guys can do. Small step, grab a digital copy of this. I'm going to share the link. You go right to our website and order it. It'll be right here, right now, in our chat box, right there. Maybe I can get it to click through. And we'll also send it to you guys by email so you can have it in your email. What will happen, though, is because you guys, I love my clients, is that I'm going to see who places orders tonight. And out of all of you who place the order tonight, and we'll just say before midnight, we'll draw one name at random, and I will give you the first paper copy for free as a courtesy. So you get the first trustee manual, special made for you at random. So whoever wants to do that, jump on that link. It is bit, like bit.ly/Keystone Trust Book. So all you need to type in, it'll take you to the page, and you just order it right there. And we'll be sending those out by email November 1st, okay? So jump on there and grab that if you want that. And then I've got the next, looks like I've got about 15 minutes to take some questions. And let me give my voice a break. All right, so what you'll see is a little prompt in the system that we're on. I'm going to switch us over into Q&A mode. And what will happen if you want to ask a question is you will hit a button or click something that says, I have a question. It'll kind of be, that's what you're going to do. You're going to raise your hand, and I will click on a button. It will open up your microphone, and you'll just speak out loud, and I'll be able to hear you. So what we'll do is and you'll all just kind of be dropped into a little queue, and I'll hit one after the other. Happy to stick around here until all the questions that are posted are answered. All right, so let's see here. I think we did have a question. Did we have a question in the chat box? Nope, we just had some comments in the chat box. All right, good deal. All right, so first question we have. Let me authorize our first question. All right, you are unmuted. Jeff, go ahead.
Yes, Francisco. In point 5, you mentioned heirs-at-law. Could you define who those might be typically?
Yeah, I can give you the typical definition. Yes, I'm glad you qualified it like that. The typical definition is the first. Well, let's go with a married couple. Let me scratch that idea. I'm going to go with a single person. Single person's heirs-at-law. Their first layer is their children, if they have any. And if any one of their children was predeceased, had died before them, if that child left children, then those grandchildren are also considered heirs-at-law. Okay, that's sort of one way to think about it, is for a single person. If they left no children whatsoever, then it is their two parents, their two biological or adopted parents. If they don't have surviving parents, then it is their siblings or the descendants of their siblings, so nieces and nephews. And if they don't have any survivors among siblings or nieces and nephews, it's their grandparents, all four. If their grandparents don't survive, it's the descendants of their grandparents, so uncles and aunts, second layer or second once removed cousins, and then twice removed cousins. So it goes out that far in Arizona. That's for a single person. For a married couple, it actually starts with the question of the one who died, did they have any children that were not children of their spouse? Okay, if they had children from a prior relationship, then those children are included as heirs-at-law, along with that whole framework I just described of a single person, as well as their spouse and any joint children that they had with their spouse. Is that confusing enough for you?
So these are people that essentially are often relatives but not named beneficiaries?
Correct. That is correct. They are what is called in Arizona, they are your intestate heirs.
Thank you.
You're welcome. Thanks, Jeff. see. Hang on just a minute, Jeff. I'm going to have to figure out how to mute you. There we go. All right. All right. I got a second question here. Just in the chat box. Are we able to get copies of the slides via email while waiting for the book to come out in January? Yeah, I'm happy if you guys, I will, to those who purchase a copy of the digital book, I will definitely share a copy of these slides with you and make that sort of a bonus for those who do jump on the digital copy, for sure. Good thought there. Good thought there, Reggie. I often get asked, I mean, it goes in a couple different ways. Are there going to be fees that get charged during trust administration? And the question, like any good lawyer answer, is it depends. It does depend. We always say, I want you guys to know, if you are an active trust care member with us, your trustee gets a free consultation with us at that point. Make sure they know that. Make sure they take advantage of that. We will tell them, you know, okay, here's what you got to do, A, B, C, D, and we won't hold anything back. We'll tell them everything that they have to do. Some trustees at that point, they kind of go, great, got it, I'm out of here, and they go do everything themselves. And more power to them. I don't hold anybody. That's awesome. They go, they execute. We never hear from them again. Sometimes a little sad because I like to hear the success of our family stories, but that is a success. Some trustees at that point, they go, I don't want to deal with all this stuff. Can I please hire you guys to help me do this? And yeah, of course, that's when they would then pay us fees to do that. We charge for those services. There's two ways we charge for that. One is either a flat fee if we know exactly what the scope of the project is going to be. And for most of our clients, we know what that is. And our fees on that scale can be anywhere from about $5,000 to $10,000, just depending on the scope of the estate plan. If we don't know what the scope is, then unfortunately we just have to charge by the hour, and we just march through and get the work done. We try to, help manage the budget as proactively as we can by letting your trustee do as much work as they can possibly do, and we take on the pieces that only we can take on. But the advantage that the trustee gets, if you're one of the trustees watching right now, the advantage you get by having us help you is that when you're done with the trust administration, and you go live your life, nobody can come after you complaining that you did something wrong, you owe them money, there's an outstanding bill. We've had cases where we get to the end and a bill pops up, and because things were done right, we get to send them a letter saying, hey, sorry, you don't get paid, period. You just don't get paid because we did things the right way. You didn't send that bill when you were supposed to, and it's too late. And it can save the trustee thousands and thousands of dollars. So that's the big advantage that we give trustees when they do work with us. So that's, I guess, something to take home on that. Having a co-trustee, it comes up, and I don't want you guys to leave without an answer to that question. Not a lot of people name two kids as co-trustee or two people as co-trustees to wind up their affairs. I'm not a big fan of it. I've seen it done, and I've never seen it make things better for either trustee. The beneficiaries, the expenses of the estate are always higher. The timeline is always takes longer. The grief and pain and frustration is always higher, even in the best of situations. I had these two gals came to me to administer their dad's trust that we didn't draft. They were twins. They got along like amazing twins do. They were co-trustees, and it was just a gigantic pain in the butt. That's just my experience. If you want co-trustees, you just go into it knowing that. Just imagine if we had two presidents running the nation, right? I don't think we'd ever get anything done. One is always more efficient. They have to be accountable. They have to be transparent. Everybody's entitled to all the information anyway. But if you need to stick two in there, stick two in there. Another way to do co-trustees is to name one as the primary and tell them, hey, you can appoint a helper. You can appoint somebody to help you as co-trustee. And then you have two people helping and getting the job done and sort of splitting the work. But there's one at the top of the heap. Makes things so much easier when it actually comes time to carry that out. Let's see, one more question here. John, I've got you. You should be able to go ahead and speak, John.
Could you repeat the website for your digital copy?
Yeah, you bet. It's a shortened, funny little link. So it's bit.ly, and then you're going to put a slash. I'm going to hold it up to the screen as soon as I can find a piece of paper. Then you're going to put a slash, and it's Keystone Trustee Book.
Thank you.
You're welcome. And my here we go. Let's see if this is legible. .ly/. So you're going to put. I don't know if you guys can read that. bit.ly/. And then you're going to put Keystone Trust Book. And I'm sure you all know how to spell that, but it's Keystone Trust Book after that slash. And we'll send it to you by email, so you also have a live link you can just click on.
Thank you.
You're welcome. You're welcome, John. All right. Anybody else have any other questions? If not, I am happy you all came. We will be making more info of this available to you. Also look for another class like this that we're going to host here in a few weeks about the new Secure Act that went into effect January 1st this year that affects IRA accounts. Big drastic changes that I'm not happy about, but I want you guys to be updated on it. So look for that invitation. Come back and join us. Appreciate you guys sticking with me here tonight. Have a great night, everybody.